Hello, everyone, and welcome to the webinar, Understanding Regulation Best Interest and Form CRS, featuring Carl Seiler of Blue River Partners and Scott Siebel of MCO. A recording of today's session will be made available on mycomplianceoffice.com. We'll send you an email in the next few days with a link to download the recording and slides. If you have a question for Carl, please send it to us via the chat button at the bottom of your screen. We'll be answering some questions after the presentation. And now I'd like to kick things off by welcoming Carl Seiler, Principal at Blue River Partners. Carl, over to you.
Excellent. Well, thank you very much. So before we get started with the content regarding regulation best interest and its related form, CRS, the client relationship summary, I just wanted to give the audience a little bit of background on myself. I'm a managing director and principal in the legal and regulatory compliance group at Blue River Partners. In terms of a little bit of a background on Blue River, we are essentially an independent and outsourced back office for institutional and small investment managers. Our compliance services include designing, implementing, and administering regulatory compliance programs, coordinating response plans for examinations and inquiries with the SEC, CFTC, NFA, as well as FINRA, as well as conducting simulated regulatory reviews of our clients. In terms of the composition of our client base, if we move to the next slide, yep, there we go. Our firm was founded in 2009. We have approximately 160 employees. We have over 450 separate and distinct advisory clients. You can see from the pie chart that we've included on the slide, the majority of those clients advise either hedge funds or private equity funds, although a number of them also advise institutional managed accounts within those two categories. And then the other category would include broker-dealers, who are obviously impacted by regulation best interest. We'll be discussing that in just a minute, as well as traditional wealth advisors and mutual fund managers and commodity pool operators. So moving to the background of regulation best interest, if we go to the next slide. So on June 5th, 2019, the SEC adopted a package that included two rules, and those two rules will be the majority of the content of this presentation, and that's regulation best interest and the related form CRS, or client relationship summary. But they also adopted two interpretive guidance as it relates to, one, the standard of conduct for investment advisors, and two, the solely incidental prong of the broker-dealer exclusion from registration as an investment advisor. We will touch on these last two bullet points at the end of the presentation, but the majority of our content will relate to regulation best interest and form CRS, as I said a moment ago. Going a little bit deeper into the background, so for the years following Dodd-Frank and its passage, the SEC, as well as others, have discussed tightening the standard of care that a broker-dealer is subject to when providing a securities recommendation to its clients. The latest iteration of this that we saw prior to regulation best interest was the Department of Labor's fiduciary rule, which was implemented but ultimately struck down by the Fifth Circuit Court of Appeals. One thing that I will note is with respect to regulation best interest, which addresses a heightened standard of care for broker-dealers, similar in nature to that of the fiduciary rule. It has been challenged by a number of attorneys general in several states, as well as the District of Columbia. So it's, as with the fiduciary rule, it is of course possible that it may ultimately not be implemented. Unlike the fiduciary rule, which focused primarily on investment advice being provided to retirees or retirement accounts, regulation best interest applies to recommendations that are made to quote unquote retail customers. And that's both with respect to broker-dealers as well as investment advisors. And we will get into what it means to be a retail customer or client in just a few minutes. So moving to the next slide. Compliance date. So this is really the important thing for any affected broker-dealers or registered investment advisors who have representatives in this webinar, June 30th, 2020 is the compliance date as it relates to regulation, best interest, and Form CRS. So that's the important date to keep in mind, and we'll discuss what needs to be done prior to that date on the preceding slide. So moving to the next slide. This is a basic breakdown of regulation best interest. So it applies to broker-dealers, and in the case of Form CRS, to registered investment advisors who make recommendations to retail customers, in the case of broker-dealers, or clients, in the case of investment advisors. So what does it mean to make a recommendation? And as with many things with the SEC, whether or not a broker-dealer is in fact making a recommendation is largely going to be facts and circumstances based. But essentially what it boils down to is this, is there a communication to a client, a retail customer, that could reasonably be viewed as a call to action to either invest in a security or sell a security, hold a security, or invest in certain types of security account types, an IRA being a representative example. So the important thing to note here for broker-dealers that are analyzing whether or not regulation best interest would even apply to them is it's not just a recommendation to buy or sell a security, but it also could be a recommendation related to holding a security or investing in certain types of accounts. Now, in terms of who is the retail customer in question, so the way that the regulation defines the applicable customer is a natural person or a non-professional legal representative of a natural person. And by non-professional legal representative, that would exclude representatives such as attorneys or certain types of fiduciaries. Another important thing to note is regulation best interest from the SEC differs with certain FINRA rules. So the requirement here is just that the customer be a natural person. There's no exclusion for certain types of high net worth individuals or ultra high net worth individuals. So moving to the next slide, breaking down the core requirements of regulation best interest. So regulation best interest is broken down into 4 component obligations, and they're as follows. The first is the disclosure obligation. So this is the Form CRS or client relationship summary. And this is a disclosure that needs to be in writing, that needs to be provided before at the time that advice is given, that discloses all material facts about the scope and terms of the relationship of the financial firm, either the broker-dealer or investment advisor, with its retail customers. An example of the type of information that would qualify as material facts would include the capacity in which the firm is acting when it is providing the recommendation, either as a broker-dealer or as an investment advisor, the fees or expenses incurred, the scope of the services, and most importantly, conflicts of interest. There's also a care obligation. So a broker-dealer must have a reasonable belief that the recommendation that's being made is in the best interest of the customer, taking into account risks and rewards as well as the customer's relevant investment profile. So this is where the standard of care is being heightened beyond the traditional suitability requirement of FINRA. There's also a conflicts of interest obligation. So broker-dealers must establish and implement policies and procedures reasonably designed to mitigate conflicts of interest that may incentivize associated persons to place the firm or their own interests ahead of the retail customer and to identify all such conflicts in order to disclose or eliminate them at a minimum. So very similar to the standard of care and related conflicts analysis that is traditionally applicable with investment advisors as opposed to broker-dealers. And then beyond the specific conflict of interest obligation, there's also a general compliance obligation. So all broker-dealers and registered investment advisors need to establish and implement policies and procedures that are reasonably designed to comply with regulation best interest as a whole. And as with other requirements for having compliance controls in place, the expectation for the SEC is that there is ongoing monitoring and testing related to those general compliance controls. So moving to the next slide. The basics of Form CRS. So with respect to complying with regulation best interest, the two biggest action items, and we'll get into next steps here in just a minute, but they're going to be creating the policies and procedures and drafting the Form CRS. So those in the audience who are representatives of registered investment advisors, Form CRS will not be viewed as being much different than a Form ADV brochure. So the narrative portion of an investment advisor's SEC registration, which is primarily a disclosure document. The key difference here is that it's greatly simplified. So as I mentioned at the beginning of the presentation, unlike the fiduciary rule, which was targeted primarily at retirees, regulation best interest and Form CRS are targeted at retail customers, which consistently year over year have been at the core of the SEC's examination priorities as it relates to regulating its registrants. And reflecting that theme, the Form CRS is essentially a shortened version of an investment advisor's Form ADV Part 2A brochure. Like the brochure, it needs to be crafted in plain English. The items that are covered by the relationship summary include an introduction, relationship and services, fees, costs, conflicts, and standard of conduct, disciplinary history, so very similar to the Form ADV brochure in that respect, as well as item 5, additional information. And we'll go into each item here in just a moment. As I said, conceptually, it's very similar to the Form ADV Part 2A brochure, but in a simplified format. Another important thing to keep in mind is somewhat unlike the Form ADV Part 2A brochure, but consistent with the SEC's general preference for layered disclosures. The form itself can include hyperlinks or references to other more detailed disclosures. So in the case of an investment advisor, to the extent that certain information within the Form CRS would be duplicative of information that's provided in a Form ADV Part 2A brochure, it is perfectly acceptable to provide hyperlinks, either that document or a similar document, so that in that respect, disclosures can be waived. I mentioned the compliance date at the beginning of the presentation. Again, that is June 30th, 2020. Broker-dealers need to file the Form CRS through the CRD system. Registered investment advisors need to file through IARD, and then begin the delivery requirements, which we can discuss in more detail here in a few minutes. Excellent, so moving to the next slide. So here's just a breakdown of the specific items that need to be included within Form CRS. The first is the introduction. So here, very similar to the introduction of the Form ADV brochure, this is very basic information about the firm. That's the name of the firm, the date of the applicable form, when it was last updated, the registration status of the filer or disclosure of the form as an investment advisor or a broker-dealer, and standard notices that are included within the instructions. One thing to note is that portions of the instructions for Form CRS are relatively prescriptive, similar to Form ADV, and the introduction is an example of one of those items. The next item is relationship and services. So this includes a statement of the particular type of investment advisory services that are provided to retail customers. One thing that's important to note, this and other items per the instructions of Form CRS need to include certain conversation starters. So again, consistent with the theme that this regulation is addressed primarily at retail clientele, the form needs to include questions that retail customers or clients are encouraged to ask in order to help them better understand the services that are provided by the firm. So when stating the purpose behind regulation best interest, the SEC stated that it's designed to enhance the quality and transparency of retail investors' relationship with investment advisors and broker-dealers. bringing the legal requirements and mandated disclosures in line with reasonable investor expectations while preserving access in terms of choice and cost to a variety of investment services and products. So the relationship and services portion of the form is key, because another underpinning of regulation best interest and the purpose behind its passage is that many retail customers and clients don't conceptually understand the difference between an investment advisor and a broker-dealer and the respective compensation models. Additionally, there's a significant overlap in the types of services that are provided, most notably when a broker-dealer is making a recommendation with respect to investing in a security or certain account types. So this is going to be a key portion of the form as it relates to being descriptive, and it's not quite as prescriptive as the introduction portion. The next is fees, costs, conflicts, and standard of conduct. So this would include a summary of fees, additional costs associated with recommendations or advice, conflicts of interest that may arise, including those related to certain fee models, the standard of conduct with respect to the advice or recommendation, as well as, similar to with the relationship and services item of the form, certain conversation starters that encourage clients to ask appropriate questions to better understand the arrangement and the services that they are receiving. This is likely to be the most substantial portion of Form CRS, in particular for broker-dealers. The reason being, investment advisors are not unaccustomed, again, through Form 80B Part 2A brochure, to these types of conflicts disclosures, but relatively new to the heightened standard of care provided by regulation best interest for broker-dealers. So in terms of the content of the form, this is likely to be the most substantial portion or require the most substantial work for compliance professionals. Because one, there needs to be an analysis done as to the conflicts of interest that may arise, and then there needs to be sufficient plain English disclosure related to those conflicts. Because again, at a minimum, regulation best interest requires disclosure of conflicts of interest. The next item is disciplinary history. So again, very similar to the Form 80B brochure, to the extent that the firm itself has been subject to any disciplinary event, or any agents or authorized representatives of the firm, to the extent that they've been subject to any disciplinary event, that needs to be disclosed. And in the case of the layered disclosures that I referenced on the previous slide, this would be an area where that layered disclosure can be provided. So for instance, in the case of a registered investment advisor, to the extent that they have a disciplinary disclosure, which is already disclosed on their Form 80B brochure, that fact can be stated in this item, and then a link can be provided. The last item within Form CRS is the additional information, and this would require broker-dealers and RAs to direct customers and clients to any additional disclosure information that would be pertinent based on regulation best interest. So moving to the next slide.
And as we jump to the next slide, I'd just like to take a moment and remind our attendees that if they have any questions for Carl, to use the chat box in their window to send them.
Excellent. So in addition to regulation best interest in Form CRS, the SEC also provided two interpretive guidance that were immediately effective following publication. The first was an interpretation of the solely incidental prong of the broker-dealer exclusion from registered investment advisor registration. So for those that are not familiar, to the extent that a broker-dealer, which is a registered broker-dealer, provides incidental investment advice, so it's not a key part of their business, it's not a routine service that they provide, but nonetheless, they may provide recommendations in the course of providing their broker-dealer services. Those firms are not required to be registered with the SEC as an investment advisor. Now, there have been many calls throughout the years for the SEC to provide some clarity on the types of activities that would be viewed as incidental and the types of activities that would not by the SEC in terms of reviewing broker dealers. And what this guidance did more or less was aggregate guidance that's been provided over the years and help the SEC provide the industry with their scope of view of the exclusion. The second was an interpretation of the standard of conduct for registered investment advisors. So separate and distinct from regulation best interest, investment advisors are subject to a fiduciary duty as it relates to their investment advice. And the core components of that fiduciary duty are one, the duty of care, and two, a duty of loyalty. Another important theme that applies to investment advisors, as opposed to broker-dealers in many instances, is that investment advisors need to take a principles-based approach to satisfying that duty of care and that duty of loyalty, as opposed to the FINRA regime, which is largely rules-based. This is a very important guidance that both investment advisors as well as broker-dealers should carefully review. In the case of broker-dealers, the reason why that's important is that regulation best interest in many ways is extending an investment advisor-like standard of care to the recommendations that they are making. So while this is new to everyone and the whole purpose of our conversation is just understanding as a threshold matter whether or not it applies, and if so, what we need to do about it, it would be extremely instructive for broker-dealers subject to regulation best interest to understand the SEC's guidance as it relates to a registered investment advisor's standard of care, because there's likely to develop significant parallels over time. So definitely one worth reading. With respect to the solely incidental interpretation, that's largely legalistic in nature. That one would be helpful for any broker-dealers that are just want to better understand whether or not they have an obligation to register as an investment advisor, whether or not they're providing any recommendations at all, and therefore subject to regulation best interest. But really the more helpful of the two, if you're going to read either, would be the interpretation of the standard of conduct for registered investment advisors. So moving to the next slide. So what are the next steps? So it really depends on whether or not you're a broker-dealer or a registered investment advisor. So with respect to broker-dealers, one, there should be a review of business practices to determine whether or not you have any retail customers, and if so, if you provide security or any security account recommendation to those clients. If the answer to both is yes, then proactive steps need to be taken sooner rather than later. Again, a portion of our webinar was devoted to just an overview of Form CRS and its contents, and that is one of the more substantial compliance items that comes along with regulation best interest. But it's important to remember that there is also policy and procedure requirements to ensure compliance, and those are twofold. One is that there needs to be policies and procedures in place to identify conflicts of interest, either one, mitigate them pursuant to those controls, or two, to disclose them through Form CRS. And that is likely to also be a substantial work item for broker-dealers. Again, this is something broker-dealers are not unaccustomed to having written supervisory procedures, just as investment advisors are not unaccustomed to having written policies and procedures. But it's not enough just to have those policies and procedures in place. They need to be implemented and monitored. And the expectation from the SEC is that that is an ongoing monitoring, and that there is some level of periodic or forensic testing to ensure compliance with policies and procedures. Moving to registered investment advisors, similar to broker-dealers, there needs to be a review of business practices to determine if any clients to whom you provide investment advice are natural persons. One question that commonly arises is for those that are not aware, from an Investment Advisors Act perspective, to the extent that you're providing investment advice to a pool held by multiple beneficial owners, so a mutual fund or an unregistered private fund, the question becomes, is regulation best interest, or more specifically, Form CRS, is that applicable to investment advisors of that type? The consensus seems to be no. And the reason being is that a client, from an Investment Advisors Act perspective, in that context, is actually the entity itself, not the individual investors who may or may not be natural persons. The reason for that being the investment advice is not individualized to those beneficial owners. So just as registered investment advisors need to deliver their brochure to a legal representative of the fund, the same analysis would apply here. So an important thing to note for any compliance professionals that are on the webinar whose firms advise private funds, even if the investors, or mutual funds as well, even to the extent that the investors in those vehicles are themselves natural persons, and again, there's no sophistication component as it relates to net worth within the definition, but it is unlikely to apply to investment advisors of those types. But again, very important to review business practices. If you have any type of separate account clients or a more traditional wealth advisory firm, the answer to this question is likely to be yes. And then you need to take steps ahead of the compliance date to satisfy your new requirements. So that would include drafting, filing, and delivering Form CRS, and adopting or amending existing policies and procedures to satisfy that general compliance requirement as it relates to regulation best interest. So that is an overview of regulation best interest as well as Form CRS. At this point in time, I'd like to turn it over to Scott Siebel, who's the Director of Sales for my compliance office, to continue the presentation.
And as we're turning things over, I'd just like to take one more chance to remind people that if you have any questions, please feel free to ask them in the chat box. And you can find your chat box in the very bottom part of the GoToWebinar control panel on the right side of your screen.
Great. Thank you very much, Carl. That was an excellent overview of things. It was very educational to set the stage for things. I expect there'll be some very interesting questions. I just wanted to take a few minutes to introduce my compliance office. We're often known as MCO. We have several hundred customers, RIAs, BDs throughout the world, I think about 80 different countries. We support platforms that focus on conduct risk and conflict of interest for our financial services customers of a few hundred. We've been around for about 12 years. We were originally a spin out of Fidelity Ventures, so our background definitely comes with an interesting pedigree of understanding financial services and compliance. What I'd like to just do is spend a few moments, and I'm actually going to flip into, it's a simple introduction to what we do through one slide. But what we found is over the last several years is, whereas we originally had been focused on conduct, so employee conduct. And that's where we started with employee compliance. And I'm going to transition a few different ways so you can understand the way we've evolved as the industry evolved. So when you think of, I just want to make sure that everyone can see my screen. I just got some notification. If one of the other presenters, Carl, can you see my screen?
No.
You cannot. Okay.
Not either.
Do this. Okay. No, I'm glad I asked the question. Sorry, guys.
We can now.
Perfect. Thank you. So where we started was in the conduct space, employee conduct. And what we have evolved over time is looking at understanding firm transactions. So now you start getting into conflicts of interest, and then also third-party conflicts when you think of your vendors, suppliers, and deals you may be working on. Just moving down. So when we think of the original conduct compliance, which has become conflicts of interest right away, is employee personal trading, their outside activities, their contribution, their gifts and entertainment, how they're attesting to things. And what we've also found is because there's new rules and regulations that are out there, like BI and other things, we've built ways for communication to happen between the employees, the financial representatives, and the compliance and risk departments. And we do support that through forms and then keeping track of their authorizations, registrations, and licensing. What we've also been seeing expanding beyond the conflicts that Carl was just talking about, we've also seen a lot around third-party risk. It's an evolving scene that we keep hearing from all of our customers, and becomes very interesting. Where we've also looking at conflicts is traditional trade surveillance, but then you start thinking about suitability, which we hear a lot about. What we're also finding conflicts in are the deals, and a deal can be anything that's happening within a firm. It could be a firm they're trying to acquire. It could be personal loans, or actually more on the commercial loan side. What kind of risk does that bring to the firm? Looking at restrictions across enterprises, because it's not just one business unit in asset management or the broker-dealer, but it could be something larger across the entire organization. We're also tracking MNPI and insider information, so more conflicts within the firms. I guess the summary is we see conflicts happening from the customer to the FA, from the investment advisor. We're seeing it on the institutional side. We're seeing it at the corporate level as well, where our platform is flexible enough to be able to support multiple ways to support that conflict of interest that the firms are coming against. I wanted to keep it short and sweet, so I am going to then move on, because I'd rather spend some time focusing on the questions. I think we'd all like to focus on the questions that probably came up during Carl's review of things. So I am going to hand it back to Louise and Carl.
Got it. Thank you very much, Scott. Excellent. So just a couple of questions here that I want to address. The first, and this question is come up quite a bit. So when we talk through the presentation, we focused on the obligation of a broker-dealer, the obligation of an investment advisor as it relates to complying with regulation best interest, or having to complete and distribute a form CRS. And a question that arose and that commonly arises is, what about firms that are dual registrants, so that are registered both as a broker-dealer and as an investment advisor? What is their obligation as it relates to regulation best interest? And as many people may guess, well, it depends. As with everything else with the SEC, it's largely facts and circumstances based. The good news is the adopting release for regulation best interest adopts that scenario. And what it essentially boils down to is, in which capacity is the firm acting at the time that the advice or the recommendation is being made. So if you have the brokerage arm of the firm, again, making an incidental recommendation in connection with the advice or the recommendations being made, then that is going to subject it to regulation best interest. Whereas opposed to if it is the advisory arm of the business that is providing investment advice, regulation best interest will not apply. And instead, that will be the traditional investment advisor analysis is the standard of care, specifically the fiduciary duty that applies to that advice. Another question that arose is, we talked a number of times about this general compliance obligation. So if we look again to the four components or four component obligations related to regulation best interest, the last obligation was the general compliance obligation. And what does that practically mean? It's great for a compliance professional to say that you need to have policies and procedures and you need to implement them and there needs to be monitoring, but what does it really mean? So one, what the SEC will expect there is that policies and procedures are appropriately tailored. Again, that there is periodic monitoring. And what they mean by periodic monitoring is that there is some level of verification. So it's not just enough that the compliance professionals in the firm review the policies and procedures and agree that they're appropriately tailored, they're specific to either the broker-dealer or the investment advisor's business. There needs to be some level of verification. What we recommend for our clients is quarterly testing that targets those components and documentation of that testing. In addition to testing, there needs to be periodic training. We recommend that training be conducted no less than annually. And what we expect and what many of our clients are deciding to do is devote a portion of their annual or global compliance training to regulation best interests. The last thing that's important to address in satisfying that general compliance obligation is making sure that there is a remediation plan in place. So if you are testing, then you should be discovering exceptions to the extent that there are exceptions, but you need to have a process clearly defined that you can show to the SEC in order to remediate those exceptions. And if exceptions do arise, make sure that you are adopting or documenting rather the remedial efforts that take place. Another question that arises is, when does Form CRS need to be delivered? Not in terms of the compliance date, which we wanted to make sure to carefully emphasize in the presentation. Again, the compliance date there being June 30th, 2020, but in an ongoing basis thereafter. Well, it differs as between investment advisors as well as broker-dealers. With respect to investment advisors, it's very similar to Form ADV. When a contract or advisory contract is entered into, the Form CRS needs to be delivered. And again, that would be an investment advisory contract with a retail client, so a natural person client. So the important thing to note there is it's very similar to Form ADV. Now, with respect to a broker-dealer, so that information, or rather Form CRS, needs to be provided at the time that one, a recommendation of an account type or securities transaction involving securities is made, or the placing of an order for a retail investor, or the opening of a brokerage account for the retail investor. So that is the delivery requirement. Another question that we commonly get is whether or not this can be electronically delivered, and it can, just as is the same with the Form ADV for investment advisor. However, I will note that that's not availability electronically, and that may cause, there may be some confusion because the SEC does adopt and support the concept of layered disclosures within the form itself, but just making the form generally available is not sufficient to meet the delivery requirement. It can be done electronically, but there's a specific framework that applies should you choose to adopt electronic delivery. And there needs to be a notice to the investor or the client that the information is electronically available. Access to information comparable to that would have been provided in paper form and that is not burdensome, that the recipient cannot effectively access it. And then most importantly, where we see a number of investment advisors potentially trip themselves up, is there needs to be evidence to show delivery. So in the case of investment advisors, when they're reviewed by the SEC, subject to a routine audit, they often, one of the request items under the books and records request is to show evidence of the delivery of the brochure. And we would expect any broker dealers subject to regulation best interests and Form CRS to get similar inquiries when they're subject to audit. What we recommend is, to the extent that you're using email to distribute the form, to make sure that you are requesting a receipt of the email, or possibly even using an investor portal or data room to the extent that you can utilize. So it seems that we've gotten another question in, and it says, when would there be a difference in the disclosure obligation under Regulation BI and that under Form CRS? So they're largely the same. Form CRS is intended to provide the medium, much as Form ADB brochure is, to disclose conflicts of interest. Now, it could be that a conflict of interest materializes that would require an amendment to Form CRS, but that would be largely situational. And for most established businesses, there should be consistent conflict disclosure within that form. So with that being said, I believe that is all the questions. I'll turn it back over to Louise for any closing remarks.
Thank you. And we'd like to thank everybody for attending today. For more information on Blue River Partners, visit blueriverpartnersllc.com. For more information on NCO, visit mycomplianceoffice.com. We'll be providing a recording of today's session on mycomplianceoffice.com. We'll send you an email in the next few days with a link to download the recording and slides. Thank you again for your time and have a great day.